Good afternoon, everyone, and thank you so much for joining us today. My name is Lillian Hum, and I have the privilege of serving as the Vice President of Philanthropy for BC Children's Hospital Foundation. And it's my absolute pleasure to welcome you to our virtual legacy learning series, Your Will, Experts Answer Your Top Questions. Even though we're physically apart, we are very grateful for this opportunity to come together with you, our loyal donors and friends, for this lunch hour presentation. Before we begin, I'd like to first acknowledge that BC Children's Hospital resides on the ancestral and unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. With all the uncertainty this past year, our health and well-being and that of our loved ones has likely been top of mind for all of us. And during this pandemic, changes like social isolation and rigorous health protocols have posed new challenges for many. But for children at BC Children's Hospital with serious or complex conditions, these challenges are sadly not new. This reality is just one of the many ways that the pandemic has heightened the importance of our collective work in addressing the biggest health challenges faced by kids across our province. And it is why we are so grateful that you have joined us today, as we have in particular received many inquiries from donors like you about how best to plan your legacy. And it's our honor to bring important information to you today. So over the years, we have seen the many ways you've already been partnering with us to make a lasting impact on children's health today and for future generations. Your support is making it possible for experts here to continue their quest in conquering childhood illnesses through advances like state-of-the-art technologies, groundbreaking research, discoveries, and specialized care that meets the unique needs of kids. And because of your commitment, you've shared your interest in learning more about the profound differences legacy giving can have in the lives of kids who rely on BC Children's Hospital today and in the future. Our legacy donors who embody and share this very vision form the bedrock of our supporters in the many ways they help ensure a healthier future for our kids. And today, we're here to talk about one of those ways. Your will is something you can plan and control from start to finish. And when you include a charitable legacy gift in your will, your family benefits and your community benefits. And you can take pride in knowing your values will meaningfully impact future generations. The thoughtful consideration of one's legacy oftentimes begins with the initial discussion around creating a will and about the profound differences legacy giving has made and will make at BC Children's. It also begins with knowing about the top things to consider when it comes to planning your will. And with that, we are so pleased and delighted to have three leading industry experts from Fasken join us today to share some important information to consider when making your will. With Fasken's reputation as a leading law firm in Canada and across the globe, we are very privileged to have its support of our event today. In just a moment, you'll hear directly from partner Eric Clavier, a trust and estates litigation lawyer whose practice helps his clients resolve contentious matters. We also have associates Stephen Shaw and Hiva Parandian with us as well, and they are lawyers specializing in wills and trust planning, estate administration, and charity law. We are grateful to have these three leaders join us today, and we thank them for volunteering their time to be here with us. Before I turn the event over to our presenters, I have two quick housekeeping items to note. As technology is both our friend and foe, I'd like to mention that if your screen freezes at any point during the event, you can simply hit the refresh button on your browser to help resolve that issue. And during the presentation, you will also have the opportunity to submit any questions you may have by entering them into the form below the viewing window. The Q&A with our three experts will take place later in the hour and will be moderated by Hilary Baird, our Foundation's Director of Gift and Estate Planning. Now, it's my pleasure to invite Hiva Parandian, Associate Fasken, to start us off with a general overview of estate planning. Hiva?
Thank you. It's a pleasure to be here, and thanks to everyone who has joined this virtual legacy learning series. My name is Hiva Parandian. I'm a lawyer at Fasken and I specialize in wills, trust, estate planning, and administration. Today, I'll be covering part one of this presentation, which will provide you an overview of estate planning. So when it comes to estate planning, there is no one size fits all approach. Every person, depending on his or her financial situation, family and personal background, and succession priorities and objectives, will require a different plan. And as part of that planning, there are a lot of issues to consider. A main consideration of planning is how to think about how your assets will be passed down to your beneficiaries when you pass away. Your assets can be categorized in three different groups based on how they devolve to your beneficiaries. The first category are your joint tenancy assets. So these are assets such as a bank account or a home that you co-own with one or more parties as a joint tenant. Because these assets are jointly owned, when you pass away, they will devolve automatically to the surviving tenant through right of survivorship and outside of your estate. The second category of assets are assets with beneficiary designations. So these are assets by which you can appoint whom the asset is to go to through a beneficiary designation form outside of your will. There are basically any type of registered accounts, such as RRSPs, RIFs, tax-free savings accounts, and proceeds of life insurance policies. When you pass away, if you have registered or if you have designated a beneficiary for these assets, and the named beneficiary survives you by at least 5 days, then those assets go to the surviving beneficiary directly and outside of your estate. And the last category of assets are your estate assets. So these are any other assets that you hold personally in your name. Upon your death, these assets would devolve to your beneficiaries through your will, if you have a will in place, and if you have no will, then under the laws of intestacy. So with joint tenancy planning, there are a lot of benefits, but there are also a lot of pitfalls. Because these assets are healthily joint, the process of transfer upon death is quick and seamless. Since the assets don't form as part of your estate, a will not be required for their transfer. And also, it will not be subject to the probate fees and the probate process. So probate is the process that your executor will need to take to authenticate your will by the BC Supreme Court before he or she can obtain access to your estate assets. So the process could take a couple of months and sometimes even longer. And any asset that forms as part of your estate will be subject to the probate fees, which is approximately 1.4% of the gross value of the assets. Because of probate savings, adding beneficiaries as a joint tenant to your assets may seem like an attractive option for estate planning purposes. But there could potentially be adverse effects to joint tenancy planning, which you should definitely consider before proceeding with such a plan. Number one is loss of control over these assets during your lifetime. So when you add somebody on title, you're essentially giving up control and ownership of that property. This may not be an issue if basically the person that you're transferring the asset to is the person that you're intending to receive this property upon your death. But the reality is that people change their testamentary intentions all the time. Number two is while joint tenancy planning may reduce probate fees payable upon your death, it may trigger other taxes such as capital gains tax that may be larger than probate fees if the surviving tenant is not able to use any of the exemptions that are available to avoid those other taxes. And number three, when you transfer ownership of your assets as a joint tenant to someone, that asset is not only exposed to creditors that may have a claim against you, but also creditors that may have a claim against that person whom you are transferring the asset to. So again, with beneficiary designation planning, there are a lot of benefits. Because the asset goes to the beneficiary directly, a will not be required. Again, the assets and the transfer will not be subject to the probate fees and the probate process. The process will be quick, seamless, and private. The disadvantage of beneficiary designation planning is that if you update your estate plan, you change your will, and you forget to change your beneficiary designation, then it could result in jeopardizing your testamentary intention. Also, with taxes that will be payable upon death for these specific assets, they will be borne by your estate. So if you have designated different beneficiaries to these specific assets from those that are named in your will, then the tax liability for these assets would be basically borne by the wrong beneficiary. So you want to be mindful of that. And number three is planning for your estate assets. So planning for your estate assets are typically done through your will. The benefit is that you have the flexibility to be creative for their succession. By making a will, you can ensure that your testamentary wishes with respect to these assets are carried out. The disadvantage or the pitfall is that a will is subject to the probate process and probate fees. And also, your will is subject to will's variation claim by a spouse or a child, which is a topic that will be discussed later throughout this presentation. So, will planning. Will planning is one form of planning for your estate asset, which is the last category that I mentioned earlier. So, what is a will? A will is a legal document which sets forth your wishes regarding the division and distribution of your estate assets. Why do we need to have a will? If you don't have a valid will in place, then your estate assets would be distributed pursuant to a fixed formula that is set out in the legislation in BC that deals with intestacy. So if the intention is that your spouse or your children are not to receive your estate assets, then there's no guarantee that your intent desires will be carried out if you don't have a will in place. Having a will also minimizes uncertainties and also determines the who, what, and when of your estate. Having a will also ensures proper care and planning that is to your liking is in place for your minor children or children with disability. For example, if you have a child who is receiving disability benefits from the government, they may lose their benefits if they inherit a chunk of money. By making a will, you can set up proper plan for them to ensure that they don't lose that benefit. Also, by making a will, you can defer taxes. For example, if you leave assets to your spouse, then they can elect to have the taxes deferred that would otherwise be payable upon your death, deferred to when they pass away through a spousal rollover. Most importantly, you can make certain charitable gifts and donations, which basically could assist your estate with reducing taxes that would otherwise be payable upon your death. So when you want to make a will, when you have the discussion with your lawyer, there are a lot of things to discuss to consider. I've only listed the main considerations, which is important for you to think about before you start drafting your will. The first one is basically appointing the executor and trustee of your will. So this is the person who is going to step into your shoes when you pass away. They're going to deal with your funeral arrangements. They're going to pay your taxes, pay your liabilities, take possession of your assets, and distribute them to your beneficiaries. So this person is going to have a very important role. So the person that you appoint has to be somebody who is able to do the task. You're able to trust them. Sometimes it may make sense for you to choose somebody who has a personal relationship with the beneficiaries. Sometimes it may make sense for you to choose a professional or a corporate trustee. It's really context specific. Number two, guardians for your minor children. So if you have minor children, it's important for you to appoint a guardian for them. So this is basically the person who's going to have custody of your children, and they're going to make decisions for them until they reach the age of majority. By making a will, you have to consider how and when and who inherits the estate assets. For example, you may want to leave in legacies to go to a beneficiary that's outright. Versus, for a certain beneficiary, you may want to basically have assets held in a trust for them. Any specific bequests, if you have a family heirloom that you wanted to pass down to a specific person, then that's where you would have to put in your will, and it's something that you should consider. And then what happens if there is a lapse? So that's if everybody, all the beneficiaries in your will have passed away. So if you have appointed beneficiaries that are your family members, your immediate family members, and if you guys, are in a car crash, then you want to think about what's going to happen to your estate assets if that situation happens. There may be a charity or an organization that you believe in that you want to think about, and you would want your assets to go to, and it would be a good place, to put that in your will. And then last but not least, your funeral arrangements. So if you have any specific wishes with respect to the disposal of your remains, you can certainly put that in your will. While having a will is important, it may not always be the best option for your main estate planning tool. For example, if you have a complex family dynamic, for example, you have a blended family and you want to leave unequal division of assets for your kids and spouse, then your will could be litigated and varied, and there's a risk with will's variation. So, a will may not be the best option for you. Or if you have a lot of assets that you hold personally in your name, they could ultimately be subject to probate fees and the probate process. You may want to use other planning tools to avoid these types of fees and the process. Also, when your will is probated, it becomes accessible to the public. So if privacy is an issue, then a will may not be the best planning vehicle for you. There are other planning options for you to consider, which in the interest of time, I won't have time to cover today, but I'll just briefly mention them. You can use trusts to pass down assets to your beneficiaries. With trusts, you can potentially reduce probate fees and protect your assets from will's variation claim or other challenges to your will. You can also do dual will planning, which is essentially making two wills, one will for your assets that require probate, and then one will for your assets that don't require probate, such as shares in a private company. And then essentially by doing two wills, you're reducing probate fees that will be payable upon your death. And then last but not least is joint ownership planning, which I've already covered earlier today. In addition to estate planning, which is planning for when you pass away, it's also important for you to plan for when you're alive, but incapable of managing your affairs due to incapacity. There are two main documents that you should consider when you want to plan for the time when you don't have capacity. The first one is an enduring power of attorney, which essentially is a document that allows you to appoint a trusted attorney to make your financial, legal, and business decisions for you when you become incapable. This is always recommended, especially if you have property jointly held with another individual. So if, for whatever reason, you're not able to make those certain decisions for yourself, then there's somebody else there for you to assist you with those kind of decision making. There's also an enhanced representation agreement, which is a document that allows you to appoint someone to make medical and end-of-life decision making for you. And with that brings me to the end of my presentation regarding general estate planning. I would now like to introduce my colleague, Stephen Shaw, Associate at Fasken, who will be covering the second topic of this presentation on charity giving.
Thank you, Hiva. Hi, everyone. My name is Stephen Shaw. Like Hiva, I am an estate planning lawyer at Fasken. I also advise both donors and charities on gift planning. Today, I thought it would be fun for us to discuss and to debunk some common myths about giving to charity, as well as share some practical tips with you as donors. So here are the myths. There are a lot of them. So let's get started with our first myth. Myth number one, the only ways to give to charity are by cutting a check during your lifetime or by leaving a gift in your will. These are just some ways to give to charity. There are actually many ways to give to charity. They can be as simple as changing the beneficiary of your life insurance policy or your RRSP to a registered charity. And they can be a little more complex, like setting up a trust, a donor advised fund, or even your own private foundation to give to charity. And did you know you can give things other than cash to charities? Charities will generally accept stocks or gifts of real estate as well. So that's our first myth. Our second myth is, if I give $1 to charity, I'll get $1 back in tax savings. Now, I wish this were true. However, if you do give to charity, you do get tax credits. You just don't get them on a dollar for dollar basis. How many tax credits you get depends on the amount of your gift, what year it is, and which province of Canada you live in. So as you can see from this example, an Albertan and a British Columbian, each giving the same amount to charity in 2019, will receive different amounts of tax credits. Tax credits are really important. You use tax credits to offset the amount of income tax that you pay in any given year or on death. So speaking of death, myth number 3, there's no estate tax in Canada. Now, there's no formal estate tax in Canada per se, as there is in the UK or the US. But in Canada, and here in BC, you can expect to pay, 2 kinds of taxes at death. The first is the federal capital gains tax. So under our tax rules, if a Canadian dies, they're treated as having gotten rid of their property in the moment right before their death. So to that extent that that property has any gains on it, such as if it's a house or if it's an investment portfolio, the estate must pay capital gains taxes on the gains, and that tax is roughly equal to about a quarter of the gain. Additionally, here in BC, if any of those assets require something called a grant of probate in order to administer, then that estate must pay a further provincial probate fee that's equal to about 1.4% of the fair market value of the probated assets, or $14,000 for every $1 million in estate assets. Why do I mention these taxes at death? When I talk to clients about estate planning and who they're going to be leaving things to after they pass away, they often forget that other beneficiary who is the tax man. However, if giving to charity is part of their estate planning strategy, then their estate will receive tax credits that can be used to offset the taxes that are payable at death. So you want to leave a gift in a will, for example. This brings us to our next myth. A gift in a will is bulletproof. Unfortunately, a gift in a will is not bulletproof. I recognize for the vast majority of Canadians who want to give to charity at their death, they're going to do so through a will. In British Columbia, though, you need to be aware of a couple things. First, in BC, it is possible under our laws for a spouse or for a child to challenge or even change a gift that you leave to a charity in a will. My colleague Eric is going to cover this in a little more detail. The second thing you need to know is that a gift in a will can fail if it is not properly written. So if you are going to leave a gift in a will, it's important for you to get that gift right. So let's look at an example of something that you might see in a will. Here's a clause of a gift in a will. I give $50,000 to the BC Children's Hospital to be used for Mars travel for kids. Now, for those of you watching today, I'm sure you can spot one thing that's a little funny about this clause. But did you know that there are some other mistakes here as well? Let's look at our first mistake. So the first mistake is they got the name of the charity wrong. The name of the registered charity isn't the BC Children's Hospital. It's the British Columbia Children's Hospital Foundation. Now, if you leave a gift to the BC Children's Hospital itself, it's not impossible for the BC Children's Hospital Foundation to ultimately receive your gift. It's just a bit of an administrative headache for the foundation to do so. And we know you don't want to cause that foundation headaches. So when you are leaving a gift in a will to a charity, it's important for you to get the name of the charity right. To learn what the registered charity's name is, you can go on the CRA's website, or you can go on the websites of the charities of your choice. So it's important for you to get the name right. It's also preferable for you to also add the charity registration number of the charities in your will. Number 2, the second mistake we see here with this clause is that they've given a dollar amount instead of a percentage. So there's nothing inherently wrong with giving, for example, $50,000 to the charity of your choice. But you have to ask yourself, after you make this will, what happens if the value of your estate goes up? What happens if the value of your estate goes down? What about inflation by the time you pass away? And what if there aren't enough after-tax dollars or cash in your estate to make this gift to the charity at the time of your death? So something that I recommend to clients is rather than leave a dollar amount to a charity in your will, give a percentage of your estate instead. After you make the will, if the value of your assets increase, then the value of your gift to the charity will naturally follow. It will naturally increase as well. This saves you the time of having to update your will each time that your assets, the nature of your assets, the amount of your assets change. And it saves you having to pick up the phone and call a lawyer and to have to pay legal fees as well. So that's our second mistake. And our last mistake, well, you guessed it, is impossibility. Now, the BC Children's Hospital does a lot of things. One thing I know for certain that they don't do right now is have a Mars travel program or field trips to Mars for kids. If you are going to be leaving a gift to charity, and if you are going to be having some strings attached, it's very important for you to look up the purposes and the programs of the charity that you want to support to see that they are in existence. Now, what I tell clients, and this is the safest thing to do, is don't have strings attached at all to your gift. Strings attached may be important to you, but consider this: if you leave the purpose of your gift broad, if you don't have any strings attached, then you know for certain that the gift will not fail. And you can also rest assured knowing that your gift will be used for whatever programs or whatever needs that the hospital or the charity of your choice has at the time of your death. So that's impossibility, the third mistake here. Let's look at a new and improved rewrite of that clause. So here's an example of a better clause. Let's read it together. I give 20% of the residue of my estate. Residue of my estate is just a fancy legal way of saying the remainder of your estate, to the British Columbia Children's Hospital Foundation. So we got the name of the charity right. And we've even added the charitable registration number afterwards. To be used for such of the objects and purposes as the board of directors shall from time to time determine. So we've kept the purpose of the gift broad in order to prevent it from failing. So you can already see that this is a much improved clause. Now, for those of you taking notes, I know you might be writing furiously and trying to copy this. You don't have to, because I got this clause from the BC Children's Hospitals Foundation's website. And you can find similar wording of these clauses on that website or on the websites of charities of your choice. Now, in most cases, you're going to be getting a lawyer to help you draft your will and to draft the gift clause. That's a good thing. But you have to keep in mind, you are the client. You're the one who's giving instructions to the lawyer. And as the client and as the instruction giver, it's incumbent on you to get basic things like the name of the charity right, to frame your gift as a percentage rather than as a dollar amount, and to ensure that the purposes are kept broad, or that you got the accurate purposes down in your gift. So a good lawyer would be able to spot problems with your instructions, but a busy lawyer might not. But those are some common mistakes that we see in a will, and I hope this has given you an idea of how to prevent them. This brings us to our second last myth of today, and this is a myth that we're going to cover very, very quickly. And that myth is all giving strategies are the same. All giving strategies are not the same. And I'm going to give you three very quick examples here. So the first example, if you own stocks, it is almost always better to donate the stocks in kind to charity rather than sell the stocks and give the after-tax cash proceeds to charity. If you donate stocks in kind, our tax rules are very generous. Not only do you not have to pay any capital gains taxes when you give the shares to charity, but you also get a tax credit on the full amount and full value of those stocks. So what this means is there's more for the charity, and there's also a bigger tax credit for you. Our second example, whether you are going to be donating to charity during your lifetime or whether you're going to be donating to charity at your death, there are different rules that apply as to how much of your taxable income you can offset with credits and in which years you can do so. So if you are expecting to pay a lot of tax in certain years of your life, or if you are like the majority of Canadians and you're going to be dying with most of your assets and there will be a big tax bill at your time of your death, it's important for you to talk to a lawyer beforehand or a gift planner to see how charitable giving can achieve your goals and can offset these taxes that you have to pay, as well as how best to stretch your charitable tax credits to maximum effect. The last example is a situation where you want to give to charity at your death, but you are worried about leaving it in a will. You've heard that a spouse or a child could challenge or change that gift in the will. You may also be worried about probate fees. Probate fees do erode the value of the gift. And unfortunately, unlike capital gains taxes, tax credits cannot offset provincial probate fees. So there are other ways to give to charity to your death outside of a will. And so here are a few examples. You can donate, for example, your RRSP or your life insurance policy to charity. If you do so, not only will you get tax credits for the full value of that death benefit or the RRSP proceeds, but generally speaking, that donation of the RRSP or those death benefits in a life insurance policy are not immune to, are protected from a wills variation challenge, and generally no probate fees are payable on them. So these are just some different giving strategies out there. So this brings me to my last myth that I want to share with you today. It's okay if I don't plan for the future. My kids will honor my charitable wishes. I've saved this myth for last because unfortunately it's one that many Canadians still believe in. Now, you are here today because giving to charity has been important to you, and it's going to be important to you from this point forward and even after your lifetime. But if giving to charity is your goal, and if you do not make a plan to give, whether through a will or through one of the other ways we covered briefly in this presentation, then no matter how honorable that goal is, no matter how many friends or family members you've shared that goal with, that goal without a plan is just a wish. The charity unfortunately cannot enforce that wish. And sadly, at the end of the day, the charity of your choice will not see a dollar of your wish. I hope today's short presentation both inspires and equips you to make a plan to give to charity. There are many ways to give to charity and many ways to save on taxes. It's important to understand your assets, your projected tax liability, and how giving to charity can achieve your charitable giving goals, but also offset taxes as well. And if you're leaving a gift in a will, it's important for you to get it right. Get the name right, use a percentage instead of a dollar amount, keep the purposes broad. And remember, a goal without a plan is just a wish. When in doubt, you want to talk to a professional, a gift planner or an estate planner, a lawyer, a chartered professional accountant. This concludes my portion of the presentation today. I'm now going to turn it over to my colleague, Eric Clavier, who is going to conclude with the final portion of today's presentation.
Thank you, Stephen. Hello, and thank you for joining us. My name is Eric Clavier. I am a litigation lawyer specializing in trust, wills, estates, and charities litigation. I'll be speaking on how you can avoid risks, issues, and disputes in your estate planning that may lead to litigation or contentious matters down the road. So the topics that I'm going to cover today on a high-level basis are the importance of having proper estate planning in place, who can help you with your estate plan, what is a wills variation and why it might affect your estate planning, and the importance of proper record keeping. Earlier on, Hiva explained that there are three basic estate planning tools in your toolkit. That is a will, the enduring power of attorney, and a representation agreement. But what happens if you don't have a will? Well, the first thing that happens is that you don't have control over who would be the administrator of your estate. When you make a will, you can choose the executor who is going to administer the estate. When you die without a will, there are procedures in place for somebody to apply for a grant of administration. And there's a hierarchy as to who can apply and who has precedence to apply for a grant of administration. The problem is that this can result in delay. It can result in contentious applications for estate grants. And it can also result in high costs to the people that are fighting for the estate grant or contesting it, which may ultimately come out of your estate. You also don't have any control over who your children's guardians are going to be. Now, that is imperative. You want to be able to say who is going to look after your minor children until such time as they are adults. And by not making a will, you forfeit that right and you essentially put that decision into the hands of government. The last is the most obvious. You don't have control over who gets what. While the estate legislation in British Columbia does determine who gets your assets in the event of you dying intestate, it isn't necessarily the people that you would want to benefit. So if you want to make sure that person A gets something and person B gets a lesser amount or no amount at all, if you were to die without a will, you would be forfeiting that opportunity. What happens if you do not have a power of attorney? Well, if you don't have a power of attorney, then if you should lose capacity, nobody would have authority to act on your behalf or to sign documentation for you or to manage your financial affairs. Unfortunately, once you've lost capacity, it is too late for you at that stage to appoint an attorney. So you need to make sure that you have that plan in place or that part of your estate plan in place while you still have capacity. Because if you don't, one of two things would have to happen. The first is that there would have to be a committeeship of estate. Committeeship is a fancy word for guardianship, and what it means in broad terms is that somebody would have to apply to court, be it a family member or a trusted friend, to suggest to the court that you have lost capacity and that he or she is the best person to administer your financial affairs on your behalf. That is an expensive and time-consuming process. It is also a process that can result in much acrimony. It can result in expensive litigation between family members who might want to squabble over who is going to get the keys to your financial kingdom. But what you may also want to remember is that by having a committee appointed by the court, you may not end up with the person that you would have wanted handling your affairs being the one ultimately appointed. The second option is that the public guardian and trustee will assume control of assets and decision-making. And that happens when nobody steps forward to make the application for a committeeship of estate. The public guardian and trustee, unlike an attorney, would charge fees for the duty that they fulfill, and the decisions that they make would be impersonal. They wouldn't necessarily be consistent with your wishes. So if you can avoid that, you want to have a power of attorney in place. Similarly, if you don't have a representation agreement in place, then there are limits to the decisions that can be taken on your behalf when it comes to your medical and healthcare decisions. There is a statutory hierarchy of substitute decision makers that can make emergency decisions on your behalf, but the day-to-day management of your healthcare decisions, such as whether or not you want to be in a full-time care facility or what kind of care you require, would not be available, or there wouldn't be anybody who would be making those decisions for you. Once again, there is a process where somebody can apply to court for a committeeship of person, much like the committeeship of estate. This would require a court application. It can be time consuming. It can and ordinarily is extremely expensive. And once again, the person appointed by the court may not be the person that you would have wanted making the decisions on your behalf. When it comes to your healthcare decisions, they're extremely personal. And so the risk for you is that the person ultimately appointed doesn't even know what your healthcare decisions would have been or what you would have wanted done as far as your healthcare is concerned. So make sure you have in place, at the very least, if your estate requires it, a will, a representation agreement, and a power of attorney. Who can help you with that? Well, we always recommend that you consult with a lawyer who specializes in estates and estate planning. With no disrespect to our colleagues who practice in different areas, estate plans are complicated and there is no such thing as a one-size-fits-all. There's no such thing as a simple will. The risk that you have if you go to someone who's not necessarily versed in the area, or if you use a DIY will or one that you got from your cousin or from a wills kit that you downloaded online, is that you may miss the formalities required to make a valid will in British Columbia. The Act is quite specific as to what is required for the will to be valid and to be legally binding. And if you don't comply with those, then somebody would have to go to court after your death and suggest to the court and apply to the court to find that the will is valid or can be probated, irrespective of its non-compliance with the formalities. Litigation is expensive, and this would be one of those situations that you would want to avoid. There's also the risk that if you don't use the correct process, there will be a lack of clarity about exactly what constitutes your will. Because if you have several documents that could arguably be construed as an expression of your final testamentary wishes, it might be unclear to the court when presented with those documents what actually was your will. And as Stephen has mentioned, the real risk that you run is that you try to make a gift which either redeems because it's no longer available, or alternatively, you want to make a charitable gift that you phrase incorrectly, and then somebody has to go to court to have that clarified. And then, of course, the risk if you deal with a will is that you have a will's variation action coming down the road. And if you don't have a lawyer that knows how to try and safeguard against that eventuality, then a will's variation is a near certainty. The question is, what is will's variation? I can tell you that will's variation is essentially an ability for a child or spouse of the will maker to approach the court and to say that he or she has not been properly provided for by the will maker, and to ask the court to take a red pen and to strike a line through the will that you've crafted with much care, and to change your will and vary it in such a way as the court deems appropriate and in such a way as the court deems is required to make adequate and just provision to those people who are entitled to a legal or moral obligation from the will maker. Who are the people that could apply? Who has a claim? Well, it would be either a legal married spouse or a common law spouse. It would also be available to natural children or adopted children of the deceased, but not to stepchildren. For the purposes of today's discussion, the real question is, how would a will's variation affect charitable gifts that you may want to leave? There are two ways. The first and most obvious way is that if there is a challenge to the will and the court ultimately finds in favor of the claimant and changes or varies the will, then either the charitable gift could fall away entirely, or it could be significantly reduced. There is no legal or moral obligation on any will maker to leave a charitable gift, and the court could very well step in, change the will, and the gift gets either reduced or falls away. The second risk is that even if the charity simply wants to protect its interests to the gift that you would have left them, the charity will have to retain a lawyer at its own costs, taking money from its pool of funds from other funders or donors in order to protect the gift that you would have wanted to leave to the charity. So a way of dealing with that is to consider will alternatives such as trusts, to meet with a lawyer who can advise you on that, and at the very least, if you go the wills route, to provide significant and comprehensive rational reasons as to why you are disinheriting either your spouse or one of your children. And then lastly, the importance of record keeping. You should know that as an attorney or an executor, you are in a fiduciary role. And with that role comes certain duties. That includes the duty to account. And you will need to account either as an attorney to the executor of an estate once that person passes away, or as the executor, you'll have a duty to account to the beneficiaries of the estate. So we recommend that when you become an executor or an attorney, you immediately make an inventory of all assets. You record all transactions going through the person's estate. That's money coming in, money going out. You keep the supporting documents such as receipts, checks, and bank statements. And at the end of the day, your final asset list should therefore balance, and you should be able to account comprehensively and satisfactorily for what you did within your attorneyship or your executorship. But what I can also add is that I would recommend that if you assume an attorneyship or an executorship, it's helpful to go and see a lawyer, once again, who practices within this area in order to find out what your rights, duties, and obligations are. And with that, I want to thank you for your time today. And I want to hand over to Hilary Beard of the BC Children's Hospital Foundation, who's going to moderate the Q&A.
Thank you, Eric, and thank you, Heather and Stephen. Hello, everybody. As mentioned earlier, I'm Hilary Beard, and I have the pleasure of moderating the question and answer period of this presentation. We've received a number of great questions that many of you submitted when you RSVP'd. I just want to remind everybody as well that you can still submit questions by entering them into the form below the viewing window. And if we aren't able to get to your question, not to worry. I or a member of my team would be happy to follow up with you to ensure you receive a response. To start off the question and answer, we will begin with an easy question, which I will be able to answer. It is, will this presentation be available to those of us who need to leave early? And the answer is yes. This presentation has been recorded and it will be shared after the event. We've had a few people interested in our next question. Have there been any changes to the process for creating a will during COVID times? For example, if a relative is unable or unwilling to visit a lawyer in person due to virus concerns, is there an option to not meet in person? Hiva, would you be able to answer this question, please?
Yes, absolutely, Hilary. So to give you a short answer, yes, the Minister of Public Safety and Solicitor General has issued ministerial orders, which now do allow for virtual execution of wills, powers of attorney, and representation agreements. So before these orders came into place, the Wills, Estate and Successions Act, which is the legislation that basically governs will making, basically had a requirement that when you want to execute your will, then two witnesses have to be physically present. But now they are making amendments to this legislation. They have put in a bill in place. It hasn't received royal assent, but in the future, we will be looking at basically doing virtual execution of estate planning documents permanently.
Thank you, Hiva. The next question is, if there is no executor of my will, can I choose the foundation to do so on my behalf? I should be able to answer this one. This is a question the foundation is asked from time to time. Unfortunately, the foundation is not able to act as an executor on any estate. But to provide you with helpful information on how to choose an executor, let me ask Eric to guide us on this next question, which is, what should I look for when choosing an executor? Can it be an individual or corporate? Are there things to avoid? Eric, could you answer this one for our guests, please?
With pleasure. So the very first and fundamental consideration when you choose your executor is it has to be someone that you trust implicitly. You cannot have any doubts about the executor. You cannot doubt that they're going to act in accordance with the instructions that your will provide, because if you have those doubts, you've got the wrong person in mind. So that's something to avoid. Who makes for a good executor? Generally, people try to leave the spouse or the surviving spouse and appoint that person as an executor. I would recommend against that, especially if you're of similar age, because it's quite conceivable that they're going to be elderly or alternatively otherwise unable to assume the role, or perhaps they even will have predeceased you. So rather take someone such as a child, but if you do pick a child, make sure that it is someone that the others get along with and that there are not lingering family disputes between the children, because even though you appoint an executor under the will, it is conceivable that the other beneficiaries or the other children will want to jump in and have that person passed over or removed. So if you foresee that there are risks such as that, it's probably better to go with a family member that you trust, but isn't necessarily a beneficiary or alternatively involved otherwise in the family to an extensive degree. Another option that you have is that you can appoint a trust company or a corporate trustee in order to assume the executorship. There are benefits and pitfalls to that. One of the benefits is that nobody can really question that a corporate trust company is acting independently. It has no skin in the game, but there are potentially going to be higher costs. They don't necessarily know the background to the family dynamics, and therefore you're getting a slightly less personal touch. But you certainly should think very carefully before you appoint an executor, and make sure that you also nominate some alternates, so that in the event of that person either renouncing or predeceasing you or being otherwise unable to do so, you have catered for that eventuality and made alternate nominations.
Thank you, Eric. Another question that was submitted is, what should I do if I have assets in different countries or different provinces? Hiva, can you help answer this one, please?
Yes, absolutely. So this depends on the type of assets that you have. For movable property, so that's any tangible property that you can move, the law of the willmaker domicile at death applies. So this is where the willmaker ordinarily lived or had the most connections prior to death. So for example, if you live in BC and you have a will done in BC and you have bank accounts in Ontario, then you should be able to use the will that you created in BC to deal with your accounts in Ontario. However, for immovable properties such as real estate, the law of situs, which is where the immovable asset is located, applies. So for example, if you have real estate property in Ontario and you have a will in BC, then you want to make sure that the will that you have in BC is recognized in the foreign jurisdiction, in this situation, Ontario. And in that situation, your executor will need to either get an ancillary grant or reseal your BC grant in order to deal with your real estate assets in Ontario.
Thank you, Hiva. Another excellent question is, If a will is drafted right after my child is born, how soon or likely will I have to revise it again? I can help answer this, as many people do ask us the same question. Every person should update their will whenever there is a notable event or decision that occurs in their life, an example being marriage, buying an apartment or home, etc. We have a pamphlet on key stages to update a will, and we can send that to you. And to all of our guests here, this is a resource, and others on our legacy resources page at bcchf.ca/legacy-resources. The next question is, how do I plan my charitable gift if the assets I own might change over the years? Stephen, I think you would be the best person for this question.
Well, the answer to this question really depends on the anticipated changes to your assets. And a lawyer is probably best positioned to answer this particular question in light of your current and future circumstances. I expect that lawyer, if I were him, to do a few things to help anticipate changes to your assets. And I've covered a few in my portion of the presentation. So if you are leaving a gift to charity, again, it's always best to use a percentage of your estate rather than a specific gift. For example, a car or a house or amount of cash. A percentage of your estate is better. And if you really are tied to donating a certain asset or a certain amount of cash, you could put some instructions or some wishes in a side letter, but always best to stick with a percentage rather than a dollar amount. And the second thing was to keep the purpose of the gift broad. You don't know what the charity needs at the time of your death, and so you want to keep the gift framed as broadly as possible. So those are a couple ways. And just to dovetail on what you just said there, Hillary, it's always a good idea, even if your assets haven't changed, to revisit your will anytime there's been a change in your life circumstances, or even it's a good idea just to revisit your planning every 10 years or so, or even 5 years, or even sooner, because you also just don't know what changes there have been in the law or in our tax code.
Thank you, Stephen. Another question that has been of interest to many is, if I want to designate my gift through RRSP, etc., what does the will maker need to be aware of to create the proper designation? And Stephen, would you be able to help us again?
So this is an excellent question. And there are two ways in law for you to change a beneficiary of your RRSP, or to make a designation, as you say. So the first way is to just go to your financial institution and make the change there. The second way, believe it or not, is you can change your designation or change the beneficiary of your RRSP through your will. Now, again, the best thing to do here is to seek a lawyer for advice on what to do and how to draft it. But if it were me, I would do two things for the client. The first is I would ensure that RRSP proceeds don't get paid inadvertently or intentionally to the estate, just so we don't have to have probate fees payable on the RRSP proceeds. So I would draft it in that way, and that's something that you need to talk to a lawyer about. It's not something that is DIY. And then the second thing I would do is I would just have a discussion with the client to make sure they understand the tax consequences of choosing certain beneficiaries over others to receive the RRSP proceeds. Not each beneficiary is going to lead to a tax efficient result. So good idea to walk the client through that and to see if there's any other ways to achieve their goals to benefit a certain person.
If I can just weigh in as well, I just want to caution that some financial institutions have got designation or designated beneficiary forms that contain little tick boxes where you can either have a revocable or an irrevocable designation. So you want to make sure that you make it a revocable designation, because it allows you to change your mind down the road and to change the identity of the designee.
And I'll also just quickly add to that. So thank you, Eric. I do also get this question, which is, what happens if my beneficiaries are different? I've named a beneficiary under my will for my RSP, and then the bank has a different beneficiary on file. So the very quick answer to that is whatever was the later designation usually triumphs in that situation.
Thank you, Stephen and Eric. And the final question that we will have time for today is, we have two questions that have come in about trusts. Our first question is about seeking information for trusts for a young adult with developmental disabilities, and who should administer those trusts. And our second question is seeking information on charitable remainder trusts. Hiva, you've mentioned a little bit about trusts. Have you some words on these?
Yeah, so usually when we set up trusts for beneficiaries who have a disability and, in situations where they are receiving social benefits or assistance from the government, we want to make these trusts fully discretionary. What that means is that the trustee who is going to administer the trust is going to have full discretion as to how much of the capital and income of the trust assets are going to go to that specific beneficiary. This is a requirement in order to, preserve social assistance for these individuals. And because the trustee is going to have full discretion, it's very important, who you choose as the trustee. In some contexts, as I said, it may be appropriate to choose a family member that has a personal connection with the beneficiary, especially in the context where the beneficiary has, a cognitive disability. In other situations, if this person is not available, or there's nobody in the family that you can trust, that it just may make sense to basically hire a corporate trustee or professional trustee to take care of that. The disadvantage of it is that with professional trustees, it does come with a cost. So you kind of have to basically weigh in the cost and benefits before you make that determination.
And I'll answer the question about charitable remainder trusts. So a charitable remainder trust is another way that you can give to charity. I didn't cover it in my presentation for the interest of time, but also because, frankly, it's not something that a lot of clients line up for to get, at least with me. But what is a charitable remainder trust? Well, it's a trust in which the income of the trust property is paid out over time to you or to a family member. But on your death or on the death of the key person, the remainder of the trust property itself gets donated to charity. This, again, isn't a do-it-yourself kind of way to give to charity. It is one where you should seek advice from a lawyer and possibly from a chartered professional accountant. There are specific and tricky rules with respect to timing of the gift, and who can use the tax credits and how can you offset taxes. And with trust generally, just both in terms of what Hiva was just sharing and what I just shared, they're very powerful tools. They're very effective tools, but they're also laden with a lot of traps. And so it's very, very important for you to get specialized advice for your particular situation. And I think that's the message we will leave with you.
I can just add one last comment, and that is Hiva mentioned that when you are considering your trustee, you want to consider also whether or not a corporate or a professional trust company is the way to go. So just like in the case of an executor, that is something that you have to weigh up given your factual situation. There's no one size fits all. There is a higher cost to a corporate trustee ordinarily, but you should bear in mind that generally speaking, any trustee, be it an executor or a trustee of a trust, will be entitled to claim fees under the Trustee Act. So that is not necessarily that you have one person doing it for free and the corporate trustee is going to charge you an arm and a leg. They are quite competitive, and it is sometimes a good option, especially if you're concerned about disputes between family members and if you want to avoid litigation down the road.
Thank you. Sadly, we've come to the end of our time for our question and answer period. I'm very grateful to our presenters for so generously volunteering their time and expertise today. Thank you, Eric, Stephen, and Hiva.
Thank you.
There are some questions we didn't get to. We did try to squeeze in as many as we could. And I would like to reassure everyone that if your question wasn't answered, I or Robert Hamanishi from our gift and estate planning team will follow up with you. Before we come to the end of our presentation, I would like to share that we have a special prize for one lucky person who RSVP'd. The name of the person I will draw will win a BC Executor's Guide. It's a valuable estate planning resource published by Leave a Legacy Vancouver. Now, the lucky winner is Sabrina S. Congratulations. We will contact you and mail you this guide the coming week. I hope you will find it useful. We hope everybody enjoyed today's very robust discussion. We realize that lots of valuable information was shared in the past hour about the top areas to consider when planning your will. Please don't hesitate to reach out to myself or Robert from our gift and estate planning team should you have any questions at all or you would like additional information. We are here to help. Our contact information can be seen on the screen. We are happy to provide an unbiased perspective or point you to an advisor for your specific needs. As this brings our presentation to a close, I'd like to take this opportunity to once again thank Eric Clavier, Stephen Shaw, and Hiva Parandian from Fasken for taking this time to share important information that everyone should consider when making a will in British Columbia. What you help your clients accomplish is so important to them, their loved ones, and their legacy within their community. Thank you again. I also want to thank each of you, our incredible donors and friends, for taking the time out of your busy schedules to join us. You're the reason we have and can continue to provide the best care possible to children and their families and to give them every opportunity to be healthy and fulfill their hopes and dreams. We hope today's session will inspire you to start that conversation with us around how legacy giving can help your values live on well into the future and create endless possibilities for children today and for many generations that follow. Thank you, and my very best wishes for an enjoyable rest of your day.